Okay, good afternoon. We're here for an open meeting of the Energy Facilities Siting Board. I am Meg Margaret Curran, chairperson, Janet Coy and Parag are my co-members. This is just to explain, and I believe this was in the notice of the open meeting. This is an open meeting and not a hearing. There's no public comment taken in the open meeting. This is for us, the board members, to discuss, deliberate, and decide on whatever matters are before us. On our agenda today, we have first the approval of the minutes of our prior open meeting, which was January 29th, 2016. And then we have a number of items that are on the docket. The board members will be discussing the issues that are before us, and we may also ask questions of staff. So I will ask my fellow board members if they have anything to start out with.
Again, Parag Agarwal, head of the Division of Planning, State of Rhode Island.
Okay, the first item on our agenda is the approval of the minutes of the open meeting of January 29th, 2015. The draft of the minutes have been available, or the minutes, sorry, try not to swallow. A draft has been available for us to review. Are there any changes, typos, corrections?
Yes, Chairperson. Susan, Councilor Forsyth found a typographical error on page 2. Motion to intervene filed by Sally Manzella reads erroneously, motion to intervene filed by Fossil Free Road, Sally Manzella, so we would strike with Fossil Free Road.
Thank you. Are there any other corrections?
Madam Chair, I have a few. So on the bottom of page 2, it just says whether the proposed, the last bullet should be whether the proposed project is necessary. And then more substantively, on page 4, where we enumerate the exempt licenses for the environmental aspects, both the statute and our order talks about state and federal law. So if you can track this, the first bullet is a freshwater wetlands permit issued pursuant to the state. I would strike federal and say the state freshwater wetlands act. And then for the next 2 bullets,
I just want to make sure I have that correct. So we're talking about there are a couple of bullets at the beginning. Then it says the board that enumerated the following exempt licenses.
correct.
And then the first bullet.
So there's 5 bullets there, and I want to make sure they're consistent with the statute and our order. Freshwater wetlands permit issued pursuant to the...
Can't hear you.
Microphone, please. Thank you.
Oh, I'm sorry. Thought it was on. My apologies. First bullet, strike federal and replace it with state. The second 2 bullets where we say pursuant to the Federal Clean Air Act and to the Federal Clean Water Act, I would like to say pursuant to state law and the federal. To state law and the federal.
I would like to say that. I would like to say pursuant.
I would like it to say, quote, so insert between the word to and the word federal in bullet 2, state law and, for bullet 3, after the word to and before the word the, state law and. And the point is that we have a Federal Clean Air Act, but we also have state clean air regulations that in some cases have additional requirements. For the Federal Clean Water Act, that is the Federal Wetlands Protection Law, Section Clean Water Act, but we have a state freshwater wetlands act that was also so I hope I made that clear. I apologize for not getting that in advance.
Any other corrections? May we then, there being no other corrections, may we accept them by acclamation?
Certainly.
Yes or no?
Happy to make
It's fine.
happy to make a motion too, but yes, accepted it.
I stay.
Thank you. Okay, that takes us to the motions that we have under docket. SB 2015-06, Inventory Thermal Development LLC's application to construct the Clear River Energy Center power plant in Burville, Rhode Island. Were there any matters, councilors, that we need to consider?
There are no preliminary matters other than the consideration of the three motions and the discussion of the status of the advisory committees. I believe the first motion on the agenda is consideration of the doctor's motion for evidentiary hearing on the motion to intervene. Yes.
And is there discussion on the motion for an evidentiary hearing? Is there a motion?
I make a motion.
Okay,
Oops, I'll second that motion.
all in favor?
Aye.
Aye.
Madam Chair,
So who said aye? Was it Janet?
I'm sorry, Mr. Agrawal's microphone wasn't on and people couldn't hear what the motion was. I'm sorry to.
Sorry,
I make a motion for not to have a hearing.
and that was seconded.
I'm Nicholas Storm, I represent the Walkers. I just want to make sure I'm following your edict at the beginning of the meeting. You're only considering motions today, you're not taking any argument or testimony. I just want to make sure
Correct.
you're not missing an opportunity to advocate
That's
for
correct.
my client. Okay, thank you.
So we have a motion and a seconded, all in favor?
Aye.
Next is consideration of Lyle and Aaron Walker's motion for late intervention, filed on April 11th, 2016. Is there discussion?
I just wanted to point out, as they did, that you are allowed to intervene up into a certain period before the hearing. So while it feels late, it's actually timely. And I'm prepared to vote on this, and if you all want to discuss the merits of it, I'll simply say that I'm inclined to approve this motion because I feel that the standard of being directly affected by the proposal and not being adequately represented by another party is met.
Board Member Coyle, I would like to hear your thoughts on how their interest is different from existing parties.
From what?
Existing parties.
So clearly we have two interveners
Mike.
on Long Lake Road already. Can you
Mike.
hear me?
Yes, we
Can't hear.
Sometimes we can hear you just fine.
Wallum, W-A-L-L-U-M. Okay. So this is something when I read the motion when I read the motions and the objections by the applicant, but I thought about it a lot, and this is my reasoning. There's 2 interveners already on Wallam Lake Road, so clearly interest of people who live on Wallam Lake Road in those 2 residents are represented. The issues that were raised are very similar, but property is a unique, properties and households are unique. And I don't feel that the other parties, who are already parties, who live on different houses with different families and different uses, are being adequately represented, this household. So that's my thinking. But I think it's a close, I think it's a close call because we do have interveners raising similar issues on Wallam Lake Road. Certainly aware of that.
Personally, I feel that their interests are represented by the existing parties, by the property owners who own the properties.
Speak into the mic.
I do agree that with board member Coit that yes, every property owner is unique and every household is unique, so we should respect that. But personally, I do feel that their interests are represented by existing property owners. Represented by existing property owners.
I tend to agree with Mr. Agarwal on this. I think when we consider all of the other motions to intervene and the way that we analyzed those, it doesn't seem to me that the Walkers are in a sufficiently distinct position that their interests would not be covered by the individuals who have already been allowed to intervene. So I think that I would deny the Walker motion. So is there a motion?
I move to deny Mr. Walker's motion to intervene.
I second that. Call for a vote. All in favor?
Aye.
All opposed?
No.
The motion passes 2-3.
Excuse me, to correct the record, 2-1.
I'm sorry.
Sorry.
Turn your mic
Two.
on.
It's 2-1. The next motion is David V. Harris's motion to intervene. Is there a discussion on that?
Again, I would like to hear what Dr. Coit and board chair wants to.
I'm happy to start. I am inclined to approve this motion to intervene. This is another property with an address on Wallam Lake Road. However, some of the interests that have been described involve investment and use of the property in a commercial venture. That's different from the other interveners who are directly affected on Wallam Lake Road. So I don't think that interest is adequately, in that 2-part test, directly affected, and are you adequately represented by parties already in the, who have already been approved to participate. I think they deserve to intervene and be a part.
I agree with Director Coit on this one. I do think that the argument that was presented by Mr. Harris's motion was distinguishable from the individuals who have already been allowed to intervene. So I would support that. I would support granting it.
I do agree with the board member Coit and the board chair that their application is very different than the existing property owners who are the existing parties, because they have invested significantly in the property and it's a totally different impact on them as compared to the other property owners, and they will be adversely impacted. They might be adversely impacted with this application, so their interest will not be represented by existing parties.
Is there a motion on Mr. Harris's motion to intervene?
I make a motion to approve the intervention.
Second the motion.
All in favor? Aye.
Aye.
Okay, that passes unanimously. That brings us to item number 5 on the agenda, which is a discussion on the status of advisory opinion. And we might want to ask some questions of staff. Could you introduce yourself for the record, please?
I'm Todd Bianco, the board coordinator.
Patty Ruccarelli on behalf of the board. Susan Fortier, legal counsel from DEM.
Chairperson, would you like me to begin with some of some information to help start your conversation. I spoke to staff and in some cases attorneys at the 12 agencies that have been designated to render advisory opinions. I could start with the 5 at the town and the local and political subdivisions of the town, and then move to the state. The information from the tax assessor was that they have a general consultant.
Sorry, this is the Burrillville Tax Assessor.
Yes, the Burrillville Tax Assessor's Office has a standing consultant that they use for a variety of property tax related issues in the town. And that this person would be working on rendering that advisory opinion. They expect to have that advisory opinion filed on time. I also spoke to the planning board. The planning board's advisory opinion is somewhat related to the zoning board. The planning board first takes the information they have from the applicant, will work through preliminary concept and then master plans, so more detailed plans. Typically at that stage they make an advisory opinion to the zoning board for a special use permit. The zoning board would then render its decision, which would be the advisory opinion that the zoning board would send to the siting board. They would also send that advisory opinion not just to the siting board but back to the planning board so that the planning board could do their final approval, which is the advisory opinion that the siting board has asked for. That process is happening now. It's my understanding that action on that is scheduled for June 20th and July 12th. But I'm not sure if those have been confirmed. But
When you say action on that, do you mean hearings?
yeah, those are hearings to my knowledge. Particularly the zoning board, which I'll get to next. While this is a much faster process than they're used to, different information, the planning board did say that they do expect to file an advisory opinion on time. The zoning board, which was tied in there, they have a hearing process, and the applicant will make a case. The town will also have testimony from an expert. They allow public comment, and as I said, that advisory opinion will come on special use back to the board and also to the planning board in the town, so that they can make their final decision.
Yes.
With those offices, I was also able to speak to the building inspector, who also indicated that he expects to file an advisory opinion on time. Pasco Utility District also does not see a problem with filing advisory opinion on time. They have an expert that they will engage for this, and in particular, the advisory opinion that the board asked regarding water in the town and the water supply is tied in with the DEM process to some extent, and the amount of stream flow depletion related to withdrawal. And they indicated that once they had that information, it shouldn't be too hard for their expert to render an advisory opinion. we would expect in those cases expert testimony for the board's order. So that was the 5 in the town: the tax assessor, the planning board, the zoning, and the zoning board, the building inspector, and Pasco Utility District. At the state level, the Public Utilities Commission has already begun its process to render advisory opinion. They use their normal hearing process, while the PUC has that procedural schedule set and expects to have an advisory opinion to the siting board on time. The Office of Energy Resources has engaged a consultant to help them render their advisory opinion. They will have a process that will allow parties and parties to be treated like public and allow public comment on a what's more, rather than a hearing, more like a public workshop process. They expect that to happen sometime in July on 30 days notice. However, that will not be a hearing process, and they also expect to have a witness sit in our final hearings.
Do they expect to have the consultant at the public workshop, almost like a tech session?
My understanding was that they were planning to present basically an outline, and that they did intend to have the consultant on in the next day or so, with the intent to have that consultant available for the workshop. But I am, and obviously, happy to follow up on any questions you have with these agencies. I spoke to the Department of Health. Was also asked to render advisory opinion on a couple of issues. Department of Health has a hearing process that they plan to use. They have a regulation hearing process, so they will have a hearing, comments will be accepted, they'll have 30 days notice, they can extend the comment period if necessary, and if the comments cause significant changes to what they proposed, I guess they have a process for altering what they've proposed. It's a pretty broad process, and I believe they've split the 2 issues that the board has asked between different staff, and but I don't believe it's their opinion that they have a process that won't require them to provide an expert or rather a witness, and they also expect to have that available on time. The Historical Preservation and Heritage Commission, they've already begun their process in that area. They know that some areas are sensitive. They go out, they do what's called a phase 1 identification survey. If they find some things of note, they'll move to a phase 2, so on and so forth. My understanding is that they did a phase 1, and impact areas were added, so they're out there doing for some more field work, waiting for their report, but do expect that as long as they're aware of the impact areas in time, it doesn't take them that long to do the field work and have that report, so they also expect to be submitting on time. The statewide planning program intends to use a variant of State Planning Council Rule 3.
Say it again. Seems to use.
A variant of State Planning Council Rule 3. So they'll draft in-house a report. They'll distribute it. They'll have a 10-day period to register, have the State Planning Council register any concern with the planning program. If there are any, then at their next scheduled public meeting of the Statewide Planning Council, they will meet to discuss with intent to finalize. In this case, the statewide planning program also provided some exchange that they had with the town regarding the ability to intervene in the hearing process, and it outlines that, that process that I just said, and that they are not holding hearings nor seeking submissions of information from interveners. If an intervener did submit information on or about May 16th, they could ensure its consideration. But to be clear, that was not a formal hearing process. It was something different. The Department of Transportation I spoke to a while back. At the time, they had not received an application for the 2 permits that we understand the applicant needs, a physical alteration permit and a utility permit. The most recently, on May 24th, exchange between DOT and Attorney McElroy for the town was sent to the board. We were copied, coordinator. It's available on our webpage for the docket now. Kind of the important point here is that as of May 24th, DOT is indicating that Invenergy still has not filed for those applications. It's my understanding from talking with DOT that those are minimum 3-month process. They also, with regards to the area disturbance, go to the Historic Preservation and Heritage Commission for 30 days. I believe the 3 months does include that. Today's June 2nd. So I don't have information solid. I don't believe DOT can make a determination fairly whether or not they'll be able to provide an advisory opinion on time at this point. Finally, I believe that's just DEM. The board asked DEM for advisory opinion on 5 issues. With regards to the oil, the oil storage, DEM indicated that they're collecting information on that, and they've issued data requests in the board's docket at this point. With regard to the Pasco well, I think it matters. The issue can be addressed, and they plan to issue data requests in our docket regarding that for additional information. But I believe whether or not some of the issues can be overcome regarding the status of the well is unknown at this time. But those are perhaps legal issues.
They indicated they were having any trouble getting the information necessary?
Well, they indicated that they were aware of a court order that may prevent a normal test. I should add that they also met with the town to discuss that their advisory opinions were not going to be an open process, and that they, on the 5 issues, they expect that there could be as many as 5 witnesses provided for the final hearings. With regard to wildlife and habitat, a lot of this is tied in apparently with the wetlands permit. They do know some information about the wetlands where they're outlined. They don't have a wetlands permit filed at this point. So they can, they expect that it might be a little bit tight on time, and that's their status on that. I guess a lot of these issues are tied in with the wetlands process, which is separate and apart from the board's process. With regard, the board asked about the Clean Power Plan and Regional Greenhouse Gas Initiative. I think there's no problem there with information, except for I guess how those 2 programs might change. But of course, can be written in terms of how the programs are right now. And the board asked about the overall impact on the environment. I don't think that DEM is preparing a full environmental impact document or statement that would be triggered by, say, the National Environmental Policy Act. They are certainly looking at this in terms of all regulations, and they might also have to issue data requests in our docket to get the information they need at this point.
Do they anticipate having a witness or witnesses for that?
Yes, for all of these. So that's the 12. Happy to restate any of that. It would be helpful for your discussion.
I know we, Todd, thank you. I know we talked about at an earlier meeting, making sure on the Energy Facility Setting Board website, when there are these various hearings in front of town and state entities that have advisory opinion processes, that we have that not just in the agency websites of if Office of Energy Resources is having a hearing, that we have in one place the accounting of all the public hearings and opportunities. So could we make sure that happens as you collect this, that it's also shown on our website?
We could do that, and I certainly could do a better job of that. So.
Madam Chair, I don't know if this is the appropriate time, so I'll bring that into question. I did want to, after the public hearings, and I've made clear at these hearings and public hearings that I'm here in my capacity as the Energy Facility Siting Board member, and that the DM process is being overseen by the lead staff at DM. I'm not involved in both. I wanted to expand the questions to DEM, and if this is the appropriate time, I think I would let you know what I have in mind to do, and then make a motion that we either amend our earlier order or do an addendum to our order.
I think this is the appropriate time because I also had some questions, and I still have them, in light of the status update, particularly about DEM's work and the scope of what we expect to receive. I would, since a really great reason that you're on the Energy Facility Setting Board is because you understand more about how those processes operate, even though you're not involved with them at this point. And so I would very much value your perspective on that and whatever issues you have.
Thank you. So let me spell out what, after further input on this, I've been thinking. One is, Todd, you made the point that the wetlands permit hasn't been received yet by DM, and there is a fish and wildlife habitat aspect of that permit. However, when we heard about state rare, or federally rare species, or the habitat conservation goals of the state, the National Heritage Program, I feel that a couple aspects, and if you don't mind, I'll run through all three of them, and then a few aspects of the order to DM. I think we asked in our initial order the impact on fish and wildlife that will be caused by disruption of the habitat. And my guess is that staff's expecting that to come in through the wetlands permit, but these permits don't have to be concurrent with this process. With the clean air permit, the wetlands permit could go in later, and we're asking for advisory opinions in the timeframes under this act. And I think the fish and wildlife habitat aspects, as well as the impact of the project on the state conservation priorities. And we have a state wildlife action plan, and we have a number of plans at DEM around large habitat priorities. I think they need to be considered specifically. And I was, in rereading our order, I didn't think we had said that in a broad enough way. That would likely be a review that the Natural Resources Bureau that oversees open space conservation, land and water conservation would undertake. So I have a suggestion on that. Secondly, I would like to spell out, we do have, as has been noted many times, many state conservation areas, George Washington, Buck Hill, Pulaski Park. So I think we need to ask DEM specifically about potential impacts on outdoor recreation in state-owned lands, so that's separate. And then third, while our order talks about, and it tracks the statute here, whether the facility will present an unacceptable harm to the environment, the cumulative impacts aren't necessarily part of that question. And that's another issue certainly been raised over and over again. So I would like us to ask DEM on the environmental side to take a look at the potential for cumulative impacts given the other facilities in somewhat closer proximity to the proposed facility. So those were the three, and I can read what I drafted. Those are the three questions. I don't feel that they will necessarily require an extension of the time frame, and they may even come in under our time frame where the applications for wetlands or other things may be in a different time frame. I'm not sure, it depends when the applications come in. So I can read off the changes, and then we can also obviously correct them, make sure that they're exactly right when we issue the order, but that's my thinking.
I would say, I find that extremely helpful because those are some of the same questions that I had, starting out with whether or not we would be getting the information on cumulative impact, because I was assuming that that was understood under what we had asked, and I'm glad to know that it may not be, and we can make sure that we get that information across. I was also, I'm glad to hear you mention about the different state plans and how what we're looking at here comports with them, and making sure that in fact we are representing a consistent state message in what we're looking at. And finally, also the concerns about wildlife. Again, I think that involves cumulative impact, but I'm not sure if it's not clear in the way we phrased it. We should make it clear that that's something we want to know, particularly given the threatened species. Of course, I'm partial to the bats, but all of them, that would, the bats, but also the other ones that we've heard about. I want to make sure that I was just assuming that that would definitely be covered. To the extent it's not clear, I'm glad that we have this opportunity now to tighten up our request.
Yes, I do agree. Just want to make sure DEM is also looking at the impact on water supply, right? Water resources.
We had water resources in several places, and now I'm going to have to correct myself, but we have the health department, things looking at drinking water supply. DEM was asked specifically about withdrawal of groundwater and impact on the Pasco system, the closed well. And obviously, question about overall impacts would address water. Was there one other place in the order that I'm missing?
Pasco Utility District.
And then we asked the utility district specifically about water supply.
No, so I think now would be a good time to hear your proposed language.
Sure. So let me articulate the proposed language, and then depending on how you all feel, I'll be happy to make that motion. So I would like to ask the DEM additionally to render an advisory opinion as to, this would really be number 6, so 6, 7, and 8, the proposed, what impact the proposed facility would have on fish and wildlife habitat and conservation priorities, and state conservation priorities, especially including impacts to rare species. Next, which would be 7, what impact would the proposed facility have on public recreation on state conservation lands and nearby DEM management areas? And 8, the potential for cumulative impacts if the proposed facility were to be built, given the relative proximity of the proposed facility to the existing Ocean State Power Plant and Algonquin Compressor Station. ALGONQUIN, Algonquin Compressor Station. And again, I think I would hope that the more specific language might have incorporated some of that, but based on what I heard and some of what I heard at the public hearings, I think we need to specifically spell that out.
I agree. And I would invite you then to make a motion.
I move that we issue an advisory opinion that expands the questions being asked of the Rhode Island DEM to include those that I've described.
Second.
All in favor?
Aye.
Aye.
Unanimous, it passed. Okay. Is there anything further you want to discuss?
Again, I just wanted to, I would say administrative notice perhaps, but it has been mentioned several times in the public hearings, and then it was mentioned today by Todd Bianco about the court order in regard to the Pasco well. And I think that's something that I want to make sure is part of our record.
That is a published opinion, I believe,
It should be.
and we could take administrative notice of it and include it in.
At the final hearing, administrative notice of that court.
Could we do that now, so that we've got it in there, particularly since it would be available to anyone who wanted to examine the expanded request we're making that might be impacted by them?
I don't see a reason that you couldn't do that at this time.
Would you like to move that we take administrative notice?
I will make that motion, it just makes sense. So I move that we take administrative notice of the court order affecting the closure of the Pasco well.
Second.
All in favor?
Aye. I'll make one more comment since my mic is on. At the, I think it was before the second public hearing, which was at the Burrillville Middle School, there were some fact sheets that we had asked the staff here to put together that talk about this process. And I think that was extremely helpful because there is a lot of misunderstanding for whatever reason about the process. And so I just wanted to mention that I thought those were well done, that they're available on the website, and I think they help members of the public and other decision makers understand the statute and the process. So thank you for providing those, and I think we should continue to point people to them.
Thank you for that. Yes, and I think sometimes it's easy to lose sight of the fact that this stuff is quite complicated. We know the details of the process because we go over and over the stuff repeatedly on our own, and then when we get together for open meetings or public hearings, and it does well to keep in mind that everyone else doesn't spend as much time going through the materials, and so it is very helpful, and I would like to thank Todd Bianco for the work that he did. And
Well, thank you, all staff.
Kylie Licarelli. Anything further?
I just wondered in terms of the process, we have these various hearings that are going on, not under our auspices, but under others. The next time, other than if we call for an open meeting, the next time that we would have a public meeting would be when, Madam Chair? Public hearing, excuse me. We had talked about one centrally located and then one after the advisory opinions. I just want to make sure everyone's aware of the next time that will happen, or when we're likely to schedule it. I don't think we have any dates set yet.
We'll direct that to our coordinator.
With regard to this docket, if sometime after September 10th or before October 10th, I think is the time frame that I was going to look for two public hearings. Since we're all here, if I haven't checked with your staff yet on which nights or days would work.
Okay, I just think that's important, that there's not likely to be public hearing, and the point was made that people would like to see the advisory opinions, and that's the reason for that. And there will be 2 more public hearings, but we're going to have a lull before then. I think I just want that to be clear to people.
And I will be noticing when those do happen, they get noticed in the Providence Journal. I also use a local newspaper and the Bargain Buyer, which I believe goes to every mailbox in Borough, as well as our website and the Secretary of State website.
And of course, the advisory opinions, when we get them, will also be posted on the website, correct?
Yes. Yeah, we'll have a whole section dedicated to advisory opinions.
And we do expect those advisory opinions to be posted by September 10th. We will be receiving them on September 10th, right?
So September 10th is actually Saturday, and time allows, the way our rules allow for time to be calculated, I guess, a Monday. And also, we actually ask somebody from a different agency to help us manage the website. So whether or not he's available, I would expect the end of the day on Monday, September 12th.
Maybe we should start a Twitter account.
It would be my first, but happy to learn to tweet. Hashtags, I think, are a thing that I can.
Well, I'm not sure that I can do that. I don't have advice on that, but that might be a way to be able to get information out if people don't have immediate access to the website. If we had something that we wanted to put out.
I agree, we need to get into the modern age, all of us.
Great. Anything further?
Move to adjourn.
I second.
All in favor?
Aye.
Thank you very much.